SJC-11612, Easthampton Savings Bank and others, the City of Springfield.
Before the clock starts, with regard to counsel, when a case is here to us on a certified question, it is appreciated if the questions are included somewhere in the briefs. I think I went through 7 briefs and nowhere found any of the certified questions. I think we have found them, but no thanks to you. So in the future, where we're here to answer a question, it would be helpful to us for you to tell us what the questions are that we are to be answering. But we have done that on our own. So with that, you may proceed. Ms. Saperstein?
Your Honor. Tanny Saperstein for the appellants of the banks. This case started out in the district court in Springfield and was appealed to the First Circuit. And as Your Honor stated, the First Circuit certified 2 questions to this court. The first was whether or not the mandatory $10,000 cash bond is a tax or a permissible fee. And the other was whether or not the foreclosure and mediation ordinances in whole or in part are preempted by the state statutes that were actually put in our brief. And those state statutes were 21E, the hazardous waste statute, the state sanitary code and the regulations, and the state foreclosure statute. And I'd like to start with the issue of the tax. This court has clearly established the test for what is a permissible fee and an impermissible tax. And in order to constitute a fee, there has to be a direct, particularized benefit to the person or the entity paying the fee, in this case, the mortgagees. There has to be a direct allocation and a defraying of the costs for whatever purported service or benefit is being provided. And that fee has to be reasonably proportionate to the benefit received. Well, in this case, none of those factors are satisfied by the mandatory.
It's a $10,000 bond, but most of it is to be recouped, right?
Well, maybe. That's actually not clear in the ordinance. That's one of the issues with the ordinance. There's no recoupment, accounting, or oversight provision. And actually, the ordinance...
This has not been implemented, is that correct?
Well, it hasn't been implemented because the First Circuit issued a stay.
Okay, so
Our
we don't know
What is the purpose of the bond? What are the, I guess maybe we could get it this way, what are the proceeds of the bond to be used for?
The purpose...
Ordinance, under the ordinance.
Under the ordinance. The purpose of the bond is actually to be used to secure and maintain vacant buildings in the city of Springfield. Not only buildings that the mortgagee posts the bond for, but other buildings as well, which is actually one of the issues and makes it, at least in our opinion, a tax, not a fee.
But it doesn't, just on that point though, I thought the city argued that at the point that the property was sold or foreclosure occurred, maybe I misunderstood it, but if buildings on that property had not been, money hadn't been used by the city to deal with that what would be returned to the bank would be everything except for an administrative fee of $500 or something. Is that right?
Well, that's nowhere in the ordinance. That is actually what they argued. I believe one of the issues that the First Circuit had was that there was no accounting and there was no oversight.
But do I understand what they said? Is that what they
said?
said?
Yes, Your Honor. But that's not actually in the ordinance anywhere. And nor is the amount of the purported administration fee. But the most troubling portion of the cash bond is that it can be used for other buildings that the mortgagee has no interest in, and that is in the ordinance. So in other words, if there is a vacant building next door to one of my client's buildings and they post a $10,000 bond and another mortgagee has an interest in that building and that building is in disrepair and foreclosure has been initiated, my client's bond can be used to rehabilitate that building.
But it's going to be paid back to you when your client's property is sold. Is that
But how
correct?
much? And what's it going to be used for in the meantime? One of the issues with this statute, and I believe one of the reasons that the First Circuit issued the stay, is let's assume that this is allowed to go forward, and eventually the First Circuit decides that there's a preemption issue or a tax fee issue, and the bond is spent. Then how would the clients be repaid?
Well, you say that, but I'm looking at the language of the statute. Provide a cash bond acceptable to the commissioner in the sum of not less than $10,000 to secure the continued maintenance of the property throughout its vacancy and remunerate the city for any expenses incurred in inspecting, securing, marking, or making such building safe. That seems to say it's only your building.
Well, and other such buildings that are not in compliance with this article.
I'm sorry, where are you reading?
Well, I'm reading in my appendix.
Oh, a portion shall be retained by the city as administrative fee to fund an account. Yeah, that's for the administrative fee
Well,
to
it
fund an
says-
account.
It says, provide a cash bond acceptable to the commissioner in the sum of not less than $10,000 to secure the continued maintenance of the property throughout its vacancy and remunerate the city for any expenses incurred in inspecting, securing, marking, or making such buildings safe. A portion of said bond shall be retained by the city as an administrative fee to fund an account for expenses incurred in inspecting, securing, and marking said building and other such buildings that are not in compliance with this article. Not
That's
necessarily.
only in inspecting, securing, and marking, not in maintaining.
And that's part of the administrative fee, right?
No, I think that's actually part of the inspecting, securing, and marking that building as well as other buildings that are not in compliance with the state sanitary code. That's actually the problem.
And if it were to be interpreted to say that that if it's, if the fee may, that apart from the administrative fee, it may be used with regard to maintenance only with regard to the particular building for which the bond is granted, that would be okay?
Well, that would make it maybe more a fee, but the problem is we still have the other tests for what a tax versus a fee is. So what is the actual particularized benefit that the mortgagee is getting? Now,
Well, isn't part, I mean, the argument I gather of Judge Ponser, as I understand it, was to say, you have an interest in preserving the value of your property. And if there are foreclosed properties going to hell all around your property, it's going to diminish the value of your property and diminish the value of the amount that you will receive upon foreclosure. Why is that not, why is this concern about avoiding blight not something which benefits the bank as well as the city?
as well as the city, Your Honor, and as well as all of the other property owners in the neighborhood. So how is that a particularized benefit? If in fact everybody, and it will agree that if the city rehabilitates all of the buildings in the city of Springfield, everybody in the city of Springfield that has an ownership interest in property or a mortgage is going to benefit. But why tax the mortgagees who initiate foreclosure to pay for that? The other purported benefits were that there will be a database, which actually there already is in the city of Springfield. Mortgagees that are about to foreclose already register their properties, and they pay a $100 registration fee and give the city the information that the city requires. They also said that there would be real estate market stability and the property values would continue. But again, that's not a particularized benefit.
Well, yeah, it's a particularized benefit to property owners. It's maybe not particularized in a particular, for an individual property mortgagee at the time of the sale, but being the class of mortgagees is benefiting from this as opposed to all the people in Springfield.
But they're not benefiting any differently than anyone who owns property in Springfield. If you stabilize the real estate market,
Well, yes, they are, because they are in the process of trying to sell it.
well, they're in the process of foreclosure.
Right, but I take it there's a foreclosure sale.
Well, that's actually one of the issues, but this ordinance kicks in on the initiation of a foreclosure. So when the soldiers and sailors complaint is filed, which is, in Massachusetts, a very long time from the sale, that's when this kicks in. So if the mortgagee.
You don't even do the soldiers and sailors unless you're intending to go forward with a foreclosure proceeding.
That's correct,
right?
Your Honor. So that the initiation of the foreclosure sale, this ordinance kicks in and requires a $10,000 cash bond that only, that doesn't benefit just the property that the mortgagee is foreclosing on, but any other building that the city wants to use the money for. So with the particularized benefit to the mortgagee escapes me. In addition, the city of Springfield acknowledged in, I think it's one of its briefs, that the money would also
Step
be
back. Do
used.
you agree with Justice Botsford that foreclosed properties by their very nature are about to be sold?
That's right.
So there is a subset of properties which are going to be sold imminently.
Well,
Distinguish you from any other owner.
I would argue with imminently in Massachusetts. It usually takes a while. It takes a year or more, but
Okay, so
they
those-
will be sold.
So you are part of a subset of properties that are going to be sold within a year or two.
Yes. But so is anyone else who puts their property on the market in the city of
Right,
Springfield.
I see your point.
So, and in addition, the city has stated that in part, the bond would be used to combat blight in the city of Springfield, to fund operations, to finance litigation if mediation didn't work. And that, again, sounds a lot more like a tax than a fee because there's no particularized benefit to the mortgagee posting the $10,000 cash bond. This court has struck down similar kinds of fees. And the ones that are generally upheld are the ones where, for example, if you have to dispose of remains and for a burial and you need a permit, and there's a processing fee for the permit, that's clearly a fee. I think we can all agree there's a benefit. You want to process the remains, and you need a permit, and you pay for it, and you get the permit. In this case, the $10,000 cash bond goes well beyond any administration fee or any permit.
Well, I didn't go back and look, and maybe this is totally irrelevant, but the case that involved, is it Danvers? Probably somebody cites it, but it's about the cleaning up the water supply system in the city of Danvers or somewhere on the North Shore.
You're talking about linking to the sewage?
Yes.
Right.
Yes.
Right, that was actually more a preemption case, but I think, if I'm not mistaken. And that
I
was,
thought there was also a tax issue argument
it was,
there.
but the issue in that case is that there was a particularized benefit, and the benefit was, there had been a consent decree between the Department of Environmental Protection and Danvers.
So wasn't there an argument that it didn't really get particularized to the particular people that were going to have to pay?
Well, there was that argument, but this court held that what they were getting for that fee was, there was a 10-year moratorium on hooking up to the sewer system. What they were getting for that fee was being able to hook up to that sewer system before the 10 years. So it was a real estate development, it was a subdivision, and instead of having to wait 10 years, they paid, I don't remember what it was, whatever the fee was, and they didn't have to wait the 10 years, and they got that, but no one else got anything. No one else in the town of Danvers got anything. It was just those real estate developers that paid the fee. That is a fee, and they are getting something. This is more spread out and is more like a tax. When we were arguing in front of the First Circuit, there was some concern on the part of the judges that there was preemption, serious preemption issues between the foreclosure ordinance, the mediation ordinance, and several state statutes. And the particular state statutes that were in conflict, at least the First Circuit thought might be, were 21E, the state sanitary code and the regulations, and the foreclosure statute. And the first thing I want to do is just clarify that the standard for preemption is not a sharp conflict between the local ordinance and the state statute, and this court has actually never held that there has to be a sharp conflict. In fact, recently, in the St. George's,
Agree that that phrase is used in the Bloom case.
it is used in dicta, but actually in a recent case, the St. George Greek Orthodox Church case, what this court said is where the legislation deals with the subject comprehensively, it may reasonably be inferred as intended to preclude the exercise of any local power or function on the same subject, because otherwise the legislative purpose of that statute would be frustrated. And that's St. George Greek Orthodox Cathedral of Western Mass versus the Fire Department of the City of Springfield. That was a 2012 case. The sharp conflict language was more like dicta in the Bloom case, and that language actually I haven't been able to find in any of the cases that have come after where preemption is issued, that specific requirement.
Now, would this conflict go away if it were limited to mortgagees in possession or control?
That would help a lot. That would certainly help
Would
with...
it solve the problem?
It would solve one of the problems. It would solve the
What
problem...
problem would it not solve?
Well, it would solve the problem with the state sanitary code and the regulations, because mortgagees in possession are clearly responsible, and we all agree with that. They're responsible for maintaining the building. They possess it, they control it, they own it. And it would probably solve the problem with the foreclosure statute, because one of the issues with these ordinances is it blurs the distinction between a foreclosure by entry, by possession, and a foreclosure by sale. And there is a very distinct and very rigorous procedure to go through when you foreclose. The one it might not, and I just have to review the ordinance, is the 21E, because lenders are given a safe harbor as far as dealing with hazardous waste. But the problem with these ordinances is that there is a tacit admission in the ordinance itself that there are conflicts with state law, because a lot of the obligations that are placed on mortgagees who are not in possession, there's language in the ordinance that says unless prohibited by state law or unless not required by state law, and probably more troublesome, there's a level of discretion given to the building commissioner and the fire commissioner to either enforce these ordinances or not enforce these ordinances. And so what will happen is a mortgagee will turn to counsel for advice and say, do I have to do this under state law? They'll probably get the advice that they don't. And then not only do we have a patchwork of ordinances across the Commonwealth, but then we have each city deciding on a case-by-case basis what's going to be enforced against any mortgagee.
Is there conflict that you're being asked to do something that you're not required to do under state law?
I'm sorry.
Is the conflict that you're arguing that you're being required under the ordinances to do something that you're not required to do under state law?
That's exactly the conflict.
So I think Judge Posner said there's nothing that actually stands in the way of you doing both.
But that's actually not the standard that this court has applied for preemption, whether we can do both. And in fact, there are a couple cases that came out recently. Two dealt with utilities, I believe, and one dealt with, one was the Boston Gas Company versus the City of Newton, and one was another utility case, which said that the standard isn't whether or not you can comply with both. And in fact, one of them was there were fees assessed against a utility company that weren't assessed under the state statute, and there was something dealing with utility poles that were taken down, and that the ordinance required more than the state statute. And this court struck those down and said because there was a comprehensive scheme and because they were requiring something that wasn't required by the state statute, they were preempted. And I do cite those in my brief.
Thank you, counsel.
Thank you very much.
Good morning. May it please the court, this is Attorney Thomas Moore for the City of Springfield.
Mr. Moore, would you agree that the $10,000 cash bond that has to be posted can't be used by the city to fix up some other buildings that aren't part of the foreclosure?
Your Honor, I agree that the city is not able to do that. The language of the ordinance casts something of a wider net. Your Honor, or maybe it wasn't Your Honor, it was another one of the justices correctly stated, this is, in a sense, a hypothetical legal question. There is no implementation of the ordinances. They have not been enforced in any way, shape, or form.
But would you agree that if the ordinance was interpreted to give the city discretion to use that $10,000 to fix up whatever buildings it thought needed to be fixed up, that would be a tax of sorts and would be an improper use?
It would be problematic for the bond, absolutely, Your Honor. And I believe
Problematic for the bond, but it would be problematic for the city as well, I would think.
I think in that provision of the ordinance, yes, I agree, Your Honor. And I believe that the city's intention for implementation is to specifically set out regulations that address some of the ambiguities that have kind of been discussed by my sister council.
Is it on that score, and maybe I don't understand this quite, but is it the thought that the administrative fee, which I think you say would be $500 or something?
Approximately. In the district court, I did make that representation, yes.
Okay, so let's say it's $500. And so the Easthampton Bank sells its property, it gets back $9,500, right? And then you have a whole bunch of sales, so you take those $500, and that makes a fund, and you might use part of that in a more general sense than just Is that what you're
I think
thinking?
that's correct, Your Honor. And to be even more expansive on that subject, the administrative fee is really what it sets out to be. It's a fee for administration of the program that's established through the ordinances. The city has a finite amount of resources and at the moment does not possess the ability to put forth the program and fully enforce it. There are a number of code enforcement inspectors that will need to be hired. There's a database that's going to grow in size and will need to be more closely maintained. As my sister accurately states, there's an existing vacant and foreclosing property ordinance that the city has on its books. These two ordinances are really an extension, a large extension of what was already in place for owners of vacant property or foreclosing entities
And
for
is
vacant property.
is the benefit, on this tax fee question, the benefit that the city articulates, is this because these are foreclosing sellers, it is to their particular benefit to have both their own properties and the other foreclosing properties be in as best condition as possible, because that's going to increase the value of the property?
Yeah, that is
the-
correct, Your Honor. And I would take it a step further, too. In the city's brief, we discuss there's a very particularized benefit that is given to the registers of the ordinance, the people paying the fee and being registered in the database, and that is they are essentially put in a position that they would not have been in had they paid the fee, where the city code enforcement department receives a complaint to the property, it runs through its database, who's registered, who's responsible, who are the boots on the ground, who do we need to call to resolve this issue. That phone call is made, at least this is in theory when it's in implementation, that phone call is made prior or before any act of a citation is issued to a property owner. And as I'm sure the court is familiar, in this limbo area where a foreclosure process is initiated to the point of the actual gavel falling at an auction, there are many months and potentially years that go by where the property sits in limbo, and enough of these properties are sitting in limbo together. We see what's evident in the city of Springfield.
A question for you, please.
Yes, ma'am.
When I go to City Hall and I ask for a copy of my birth certificate, I get back a piece of paper that tells me all of the pertinent information that a birth certificate contains. I have something tangible in return for the fee that I've paid. So here, I don't see that. The property owners, the mortgagees, don't have something tangible.
Your Honor,
that
you're right.
they
There's
can-
no document that they would get back that say, I'm a registered member in the database. What they do receive, in addition to the well-regulated industry and in addition to the preservation of a property value of a property for imminent sale, is essentially what I was speaking to just previously, is that
I know, and I'm just trying to get you to look at how different the two benefits are. And maybe that's a problem for the city if you can't say precisely and clearly that something of value is being transferred. I mean, everybody gets value from the city's collection of taxes. I mean, collection of garbage. I mean, I know that's a different story because that's covered under the under your taxes, but there are probably other things that are involved that I can't recall right now, where there's a clear link between the cost and the benefit. Here it seems to be somewhat attenuated.
Your Honor, the city believes it's a clear link, but you're right, there is a distinction made. There's no physical item that is given to someone paying a fee to say that I received this as opposed to members of the general public who have not. What they do receive is a very clear and discernible financial benefit. They don't incur the cost of dealing with the legal system should the property end up in a code enforcement action in the housing court, where they then have to step in somewhere down the line with an absentee owner, costs incurred against the property for the city choosing to file an action and enforce whatever sanitary code or building code that they were looking for. And when they go to do a sale, not only are they benefiting from the security and preservation of the property when they go to do a sale and receive more money from the property, but they're literally saving legal costs and other finite costs by not having to go forward and step in a prosecution action, or a civil action, excuse me, where the city is prosecuting a property owner and looking to lien the property for the cost of what they would be doing through the registration program. I see it as a real benefit, an actual financial benefit on paper that they may not see when they pay the fee, but that is very real and is there at the end of the process when the sale takes place.
While I have your attention, let me just ask another question. When you started, you talked about the ordinance being cast far more broadly than the city intends to enforce whenever that does happen. So how do we address what the city might intend to do? I mean, isn't our job to look at the ordinance as written?
Your Honor, I would agree. It's a difficult position to be put in because we are, in a sense, putting a cart before the horse, and the city has written the ordinances, plural, in such a way that they're casting a wide net. And the foreclosure, the mortgage lending industry is a complex industry that is highly regulated. There are, I believe, in the mass bankers weighed in as an amicus brief and included, I think, something to the effect of 20 different statutes in the Commonwealth that regulate different aspects of a mortgage contract. Now, I think what the difficulty with the ordinances is the city is faced with a problem that it sees on the ground. The city councilors and the mayor and the people in the community see the issue that needs to be solved. They look at the problem and say, this is a large problem that involves not just property owners, but it also involves mortgage lenders who are involved somewhere down the line as the property falls into disrepair. How do we effectively legislate some remedy to this issue that brings some relief to the city where there is this great public health and welfare concern, where they're operating in the furtherance of their police powers and saying, we're going to write legislation that says a wide variety of things dealing with this issue. What we're going to need to do is to enact regulations and enforce the ordinance so that we don't end up falling back on the caveat catch-all clause, which has been referred to before, which essentially states if there's a conflict with state law or you exempt with state law, that you are not required to comply with the ordinance.
So,
The problem is, however, that the state has some laws which arguably put responsibility in very specific places uniformly across the state for sanitary codes, for upkeep, for cleanup. And what you're saying is that's not good enough for the city. We want to shift responsibility, make it flow earlier to other people who are not responsible under the state code. And isn't that inconsistent with the sort of uniformity that the state is trying to ensure, and consistency across the whole?
I don't think the city sees it that way, Your Honor. I think from the city's perspective, it incorporates the sanitary code and all of its provisions within the ordinance.
Or make somebody else responsible for living up to it?
Well, I think it says specifically in the ordinance that the sanitary code must be complied with by the registrars of the fee, either that being, again...
But otherwise, without that ordinance, they would not be, right?
Possibly not, Your Honor. Mortgage contracts are complicated documents and often contain clauses that allow the mortgage company the right to step into a property, preserve, to make repairs, to, in a sense, take the asset and secure it. And that's a very common provision in mortgage contracts.
And if they were to do that, would they be a mortgagee in possession, or am I just...
I think at that point, stepping to the property, they would end up being a mortgagee in possession. However, there are a number of areas where vacant property falls kind of in this gray area where a property owner is sitting with the property in his name without the gavel falling at a foreclosure sale, where the bank has made representations to tenants at the property, has taken some steps without physically entering the property to essentially say to everyone in the known world, we are the controllers of this property. We are, quote, in control of the property. And that's really where the city looks at this and says, if a bank and a lender in a mortgage capacity is in control of the property, then they should be subject to this ordinance, and that this is a valid exercise of the city's home rule authority.
But part of my concern I have is that if I have a home in Springfield and the bank is foreclosing on me, I of course can fight the foreclosure, but under the ordinance, upon the filing of the complaint in the land court, they can be fined for not draining all the water from the plumbing, removing hazardous material. I would say, I'm still living here. This is my home. How can they be punished for not invading what is still my home just because they happen to be seeking to foreclose upon it?
Your Honor, I think that would speak again to the city's difficulty in implementing this ordinance, that it would, the city in drafting the ordinance anticipated there may be issues where the city's pursuing an entity that in the end turns around and says, I am not the responsible party, or I'm involved in an adjudication at law where I'm trying to clear title to this property. In that case, the city does not anticipate pursuing those entities or individuals.
But how can we look at this and figure out answers to these questions where it sounds, listening to you, that what will happen on the ground is very different from the broad language of the ordinance?
I think, Your Honor, it speaks to the complexity of the problems with each property. Individually, each property sits in a different position than its neighbor may.
But you've said, you're going to have regulations that, for example, that deal with this issue of the ordinance saying, well, yes, an owner, as broadly defined, has to do X, Y, and Z, but not if it conflicts with state law. Well, that obviously needs to be fleshed out, right? But I don't know how we are supposed to deal with that if we don't know how it's getting fleshed out.
Your Honor, I brought this issue up very briefly at the district court and when I spoke about the timing of this action, and that the lenders who brought these challenges, the action is premature in the sense that we don't know, the city has no knowledge of whether the lenders who brought this action will actually have any mortgage contracts that are subject to this ordinance. So
Are you in the process of trying to develop those regulations, or you're just waiting to see what happens to the litigation?
Your Honor, the city was near completion on the regulations when the order to stay came down from the district court, or from the appeals court at the First Circuit. So as it stands now, the city would be ready to go forward with implementation within a period of weeks. So there are regulations that have been drafted, there's nothing that's final, and there's certainly nothing where if you said today, go forward and enforce, the city would be ready to do it today. But it would be a short period of time.
So what do we do if we say it is overbroad, but if it was narrower, it would be okay?
Your Honor, I'm not sure I have a great answer to that. I think in a perfect world, we would have a scenario where we had facts to draw upon from the ordinance itself being implemented. We do not have that. So what we have is the bank essentially saying, the lenders in question essentially saying, the sky will be falling. We are worried about X, Y, Z happening. None of that has happened, and none of that may happen. But that's why we have concerns, and that's how I understand my sister's argument. The city's response to that is the city is allowed to pass legislation in furtherance of its protection for its citizens and its public, and that it is allowed to implement and in a very forthright manner describe to anybody looking at an ordinance, do I fit into this? Do I have to pay or not? And the idea being the regulations will be essentially a checklist for do I fall into this category or not? If I do, this is what I need to do to comply with the ordinance. If I don't, I am not subject to the ordinance. And it doesn't put the city in a great position to have to make those types of discretionary decisions. My sister referenced the building commissioner and the fire commissioner. Their discretion is essentially in applying the building code and the fire code. So I hardly see that that's this great extension of their authority, or that there's some risk there that they would be making decisions that they were not capable of doing.
Well, what do you say about Attorney Saperstein's point that under 21E, the lender in possession has a safe harbor, whereas the city is going to use their money to clean up any hazardous material?
I think, Your Honor, that falls, at least from the city's perspective, pretty cleanly into the exemption category of the ordinance. So were a lender to be in possession and under 21E be eligible for that protection, the ordinance would not apply to them. And that is stated within the ordinance, they would be exempt from compliance. That's a good example of how the city is able to make that determination, and there really shouldn't be any questions down the road as to whether that was proper or improper. It's either a matter of fact or it's not. And I think that speaks to some, if not all, of the ambiguities that exist within the ordinance.
Can I ask you this question? I know we're over time, but just quickly. Let's assume the city said we have a lot of blight here. A fair number of the blighted properties are in foreclosure. And we really need more building inspectors, more sanitary inspectors, but we don't have enough money. So we're going to charge $500 to every mortgagee that moves to foreclose as a regulatory fee. Would that be a tax? So we can hire more building inspectors? Would that be a tax?
I think in the context you're describing it, I would say it would end up being a tax.
Isn't this exactly what you're doing?
I think it's different, Your Honor. And in this case, the inspectors were talking about the program itself. These two ordinances are meant to work together as one program to combat foreclosure. That program is essentially the need to hire these inspectors to put forward what the ordinance is looking to, the problem the ordinance is looking to solve. So if it were in a vacuum and the city were to decide, we want to combat blight generally, there's no mandate in the legislation from the city council saying this is the program you're going to undertake and these are the purposes and uses of the administrative fee, then I think we're looking at a much different situation.
Thank you.
All right, thank you.
Thank you.